Good morning, everyone. Welcome to another segment of Guberman Applebee's immigration updates. We're focusing on immigration in the news. Today, July 2nd, 2025, we're discussing a front page article from the Globe and Mail entitled "Thousands of Foreigners' Criminal Convictions Forgiven by Ottawa in Recent Years Raising Transparency Concerns." The article goes on to state that in the past 11 years, IRCC, Immigration and Refugees and Citizenship Canada, has approved over 17,000 rehabilitation applications, and in 2024, 1,390 criminal rehabilitation applications were approved, whereas only 105 applications were refused. So this is sort of interesting, but I also think that it bears clarifying that there's three different methods to overcome inadmissibility to Canada.
Right, and first it should be understood that it's extremely difficult to enter Canada if one has a criminal conviction. Canada may be one of the most difficult countries in the entire world to enter if there's any form of criminal conviction, be it a shoplifting charge or murder. So they're not exactly treated the same way, but the methodology is the same. And to answer your question, the three methods of entering Canada if you have a criminal conviction are a temporary resident permit, which we'll discuss. There is rehabilitation, which is a much more progressive, much more involved process. And then there is deemed rehabilitation, which occurs when there's only been a single criminal conviction and 10 years have passed since the end of any sentencing or fines involved.
Right. So a temporary resident permit, which is for newer convictions and situations when people kind of have a reason to come to Canada now, involves an examination of an offense where it is not within the criminal rehabilitation, which is what this article is discussing. Criminal rehabilitation is only applicable in situations where at least 5 years have passed since the completion of the sentence.
Right, and criminal rehabilitation is very important because it wipes that criminal conviction or several criminal convictions, as the case may be, off the record as far as entering Canada is concerned. So unless there's subsequent convictions which are not covered by the rehabilitation, it's a pretty powerful tool to allow people to the United States. Not the United States, to allow people to come to Canada.
For sure. So in this case, these statistics seem to pertain to criminal rehabilitation, which is the situation where you have to wait 5 years since the completion of the sentence, and then the offenses or offense rendering you inadmissible to Canada are wiped away forever. I find it really hard to believe that out of over 1,300 applications in 2024, only 105 were approved. Now, this is
105 were rejected.
Sorry, rejected.
Yeah.
So, I mean, this is speaking to criminal convictions, and there is a whole other range of ways that someone can be inadmissible to Canada. So, there's terrorism, there's medical inadmissibility, but I mean, in terms of the more, let's call them criminally adjacent things, I don't think that this is what these statistics are including, because that would be crazy.
I do tend to think, and this is editorializing instead of just giving the facts, I think it's an inflammatory article, and it's implying as though Canada is a sieve and allowing 1,300 criminals to enter Canada last year, for example. That's just not the case. The criminal rehabilitation process is extremely onerous, and the criminal rehabilitation process may be needed if someone shoplifted a piece of chewing gum, because that's theft, and in Canada it could be a summary or an indictable, a serious or less serious offense, which makes someone inadmissible to Canada for doing that, and they would have to go through the rehabilitation process. Let's imagine if someone is married to a Canadian citizen but has such a criminal conviction. The only way they're going to be able to come to Canada is if they receive rehabilitation. A pretty humanitarian approach to this.
Right. Or, I mean, something that we come across in actuality quite frequently is someone who has a drug conviction from college because, like, they had one joint and that's like the only thing on their record, and now they're a CEO of a large company that, you know, is going to come here and create jobs and whatever. So I mean, there's certainly instances when this is an appropriate tool. Another thing that I find pretty interesting is that the article states that the government has the power to issue these rehabilitations. It's important to know that it's like a discretionary power. They're not just handing them out, even though the article is suggesting that they are pretty much handed out. I mean,
well, what troubles me is that the implication is that Canada shouldn't be allowing these people in. And of course, the bottom line is, if there's an aberration, they certainly don't cite one where some massive criminal was admitted and given rehabilitation. But that's simply not the case. This is a case where people need to come to Canada for either family reasons or for business reasons, as you suggest. It's a vehicle by which they can do so. I don't think there's a country in the world that doesn't have a provision for allowing people in who have had past transgressions to prove that they're no longer that person, that they've rehabilitated themselves, and that they're admissible to the country. I mean,
right.
The implication is that this is dastardly in today's environment, and I just don't buy that.
Well, what I would be more interested in seeing in terms of statistics is how this breaks down in terms of people seeking temporary entry and people seeking permanent entry. And to me, that's far more problematic. If someone is admitted to Canada and for a temporary purpose, and they have criminal rehabilitation, there's a limited amount on their stay. And hopefully and presumably they can be tracked on that. What concerns me more is that the threshold for criminal rehabilitation applications is the same whether you are seeking to come to Canada temporarily or permanently. And the issue to me is that the vetting is not significant enough in the case of permanent residents.
Well, interestingly enough, if I'm not mistaken, the law actually says that you don't have to intend to even come to Canada to seek rehabilitation. Mm-hmm. So it's not a question of are you seeking entry for a purpose or not a purpose. I mean, what they don't talk about is the temporary resident permit, which obviously is temporary, short-term. It isn't necessarily as onerous as rehabilitation, but probably used 10 times
there
more
must be so many of those issued because the border does have the capacity to issue those on the spot. But let's be clear, those are often for an extremely short amount of time. That could be for someone who is transiting, you know, like to get on a cruise to go to Alaska and you have to go through Vancouver, you know. Often that's used for, you want to see your favorite band play. The drummer in the band probably has criminality. Well, he wouldn't be able to perform unless he could get a temporary resident permit.
And let's face it, the most frequent grounds of inadmissibility, I would guess, because I don't have statistics, is probably a driving while impaired, a DUI of some sort, anywhere in the world, and you're criminally inadmissible to Canada. And as I said at the outset, we probably have the most onerous admissibility issues with driving while impaired of any country in the entire world. So you require a temporary resident permit, or you require rehabilitation, or you have to wait 10 years if it's a single offense to be deemed rehabilitated. And the suggestion in the article that somehow we're porous and allow people in, I think is erroneous.
Okay, fair enough. Well, stay tuned for our next segment where Guberman Applebee immigration lawyers discuss immigration in the news. Thanks for tuning in, and follow us on YouTube, Instagram, and Twitter. Thank you.